On behalf of AIPPI, welcome to today's webinar, which is a panel discussion on the proposed TRIPS waivers for IP rights associated with COVID vaccines and treatments. This panel will provide an overview of the proposed waiver and requests to the WTO and discuss some of their implications from intellectual property, economic, and World Health perspectives. This webinar was organized by AIPPI standing committees on TRIPS and on free trade agreements. I'm Sharon Israel. I'm chair of AIPPI Standing Committee on Free Trade Agreements. I'm also a member of the US group and a partner with Shakardi and Bacon. We have a housekeeping slide. Any questions to the panelists can be submitted via a Q&A box. It should be at the bottom of your screen. And for any technical problems, you can send a message in the chat box. So our panel today will be moderated by Professor Sapnakumar. Professor Kumar is a Law Foundation professor at the University of Houston Law Center, where she's also the co-director for the Institute for Intellectual Property and Information Law. She's an expert in US patent law and has written extensively about administrative and international issues relating to patents. And now I will turn things over to Sapna to introduce the rest of our panel, and I hope everyone enjoys our discussion.
Thank you, Sharon. I'm going to briefly introduce our panelists. With us today is Tony Tellman. He is the Director of Intellectual Property Division of the World Trade Organization. We also have Hans Zawa. He is the Deputy General Counsel and Vice President for Intellectual Property at the Biotechnology Innovation Organization. And last but not least, we have Dean Baker. He is a macroeconomist and the co-founder of the Center for Economic Policy Research in Washington, D.C. We have a lot of ground to cover today, but I'll try to leave a few minutes for the Q&A. But let's go ahead and jump into things by discussing the proposals that are currently before the World Trade Organization regarding waiving IP rights for COVID-19 related drugs. And Tony, I was hoping you could start us off by telling us more about these proposals.
Thank you, Sapna, and thank you, Sharon and AIPPI colleagues for the chance to join you today. I would like to mention we really value the dialogue and collaboration with AIPPI. The practitioner insights are always very valuable for our work. I should also mention that I work for an intergovernmental organization. I'm just in the Secretariat. So I'm not speaking on behalf of our members who run this process, who own this process, who own the building behind me. So this is a technical level briefing from our point of view. So what's going on? Let me first mention that the TRIPS agreement, you're familiar with, the WTO agreement on intellectual property matters, it's not a standalone treaty. It is in fact an annex. It's an annexed agreement to the treaty that created the World Trade Organization, the WTO agreement. And this is important from our point of view because the process that's currently underway covers both the TRIPS agreement as such and the broader legal architecture of the WTO. So what India and South Africa, subsequently followed by a wide spectrum of developing country members of the WTO, have proposed is a waiver of all WTO members' obligations. The process for this is actually established not in the TRIPS agreement itself, but in the WTO agreement, the agreement establishing the WTO. And this provides, in general, in exceptional circumstances, for obligations in the WTO system to be waived to deal with the exceptional circumstances. This is Article 9 of the WTO agreement. And the way it works is that if it's about a specific agreement, such as the TRIPS agreement, then it's dealt with in one of the bodies in the committee, in our case, the council, it's called the TRIPS Council, which has specific responsibility And then its job is to receive the request and then develop a recommendation for the next level up, the General Council, which is the decision-making body. I mention that because there is some confusion about what exactly is going on, and I think the legal framework is a good way into it. What's proposed by the range of co-sponsors is therefore that certain obligations under the TRIPS agreement should be suspended, should be waived for a certain period, essentially until the challenge of the pandemic is dealt with. The scope of the proposed waiver, suspension of obligations, is, I'd say, relatively broad. It would suspend the obligations concerning copyright, concerning industrial designs, concerning patents, and concerning undisclosed information, including trade secrets and test data protection. It would suspend our members' obligations under the treaty in respect of the COVID response in dealing with the protection against the containment of the treatment of COVID-19. And for those purposes, member governments would have no obligations until the pandemic is over, essentially. Those obligations concern the substance, the rights that are granted, the IP rights that are granted and maintained, and their enforcement mechanisms, which are of course covered by the TRIPS agreement. So this was first tabled in a broader form last October, and the debate has been continuing since then. A revised version of the waiver proposal was tabled recently, and that focused particularly on the technologies that would be covered for the purpose of the waiver. And in particular, it concerns health products and technologies, including diagnostics, therapeutics, vaccines, medical devices, personal protective equipment, their materials or components, and their methods and means of manufacture. And it would be for anything related to the prevention, treatment, or containment of COVID-19. The initial period proposed for this suspension of obligations would be 3 years, and then it would go to the General Council, this higher level body, to determine whether the exceptional circumstances would have concluded. Nobody doubts there's exceptional circumstances, and yet there is not yet consensus among our members. We are 164 member governments. There's not consensus that this is the necessary or the best step to take. The majority of our members, I think, have supported it in one way or another. But there's a number of member governments who say, well, we totally agree on the intended outcome. That is to say, a concerted effort to throw everything we can at resolving addressing the pandemic, especially in recent months, looking at vaccine equity in particular, more equitable and effective distribution of vaccines to those who have found themselves sadly at the end of the queue. But there's still not agreement that a waiver of TRIPS obligations in this particular format is the right way to go. Negotiations are very intensive at the moment at every level. Multilateral meetings of all our members, more low-key, more focused group negotiations, and bilateral negotiations between member governments. So it's extremely intensive, and yet we don't have a clear landing ground for these negotiations. I should mention also that the EU has made a proposal itself that's in a distinct category from a waiver of obligations as such. What they've proposed is a clarification of the range of so-called flexibilities or the means available to governments to override particularly patent rights in the public interest. And the EU's approach has been to say, well, look, we need to clarify and make these options more workable, but within the existing legal framework. So there is, you might see it as a complementary approach, you might see it as an alternative approach, but there are two parallel discussions taking place at the same time. That said, most of the focus has been on the waiver proposal. It's been around for some time, and of course, it's attracted a lot of attention. I'll just conclude by saying what it is not, because it's often described as a patent waiver, an IP waiver, something like that. That's frankly in the wrong category. It waives it would waive the obligations of WTO members under the treaty at the international level, but it would be up to individual governments to work out how they wanted to use this additional freedom, this additional scope. And so that hasn't been resolved, because the waiver proposal is relieving governments of certain obligations under TRIPS, but it doesn't provide, if you like, a positive toolkit. And even the proponents of the waiver have stressed that they're not wishing to set aside existing options ranging from voluntary licensing to existing mechanisms, for example, compulsory licensing or government use orders to override patents and other IP. But their view is that that toolkit is not broad enough, and in the exceptional circumstances of a pandemic, governments need wider latitude of operation. That's it in a nutshell. I hope that's made it clear. Obviously, it's a very intensive, very committed debate, and I would say, if I can, for once, speak on behalf of our members, there really is a very strong determination to do what can be done to address the pandemic, but there is this still to reach consensus on the exact pathway of getting there.
That's a good segue for our other two panelists. So in terms of getting into the substance of some of this underlying disagreement, Hans, I was hoping you could tell us what are some of the concerns in the biotechnology and pharmaceutical, among the pharmaceutical and biotechnology groups regarding this waiver proposal. How will this impact innovation? What are the fears for a future pandemic?
Yeah, well, so first of all, thanks for having me. I haven't done one of these with AIPPI for a very long time. Good afternoon and good evening to all the listeners and colleagues in Europe, and good morning to everybody who might be listening from the United States, especially the East Coast. So at BIO, as a trade association, right, I do have the benefit of hearing from a lot of our member companies on the TRIPS waiver to hear their perspectives. This is certainly something that has been very attention grabbing and is being watched closely by companies large and small in the biotech space. I think the main appeal of the proposed TRIPS waiver is that it seeks to address a real problem, right? So everybody agrees, and that includes, frankly, the companies that make vaccines and supporting materials and equipment. Everybody agrees that the unequal pace at which COVID vaccines, therapeutics, also diagnostics and other products have become and are becoming available around the world is a genuine problem that's deeply concerning and must be solved for any number of reasons, right? We're not all going to be safe until we achieve global wider vaccination rates. We do not want to allow viruses to circulate for protracted times in unvaccinated populations, thereby undoing the progress that's been made with vaccination campaigns already. And we can get into all of that. I think it's important to begin with this, though, that the concern runs broadly, both through the private sector as well as governments, as well as the NGO community, that this problem must be solved. And if it won't be solved, it will have a number of detrimental effects going forward, including the poisoning of North-South relations for decades to come. Right? So this really needs to be addressed. But the waiver, what I almost universally hear from companies that have thought about this and that feel affected, the proposed waiver is a false solution. And the problem must be tackled from a different direction, because the problem has not been IP. The problems are elsewhere. They're in government policies, they are in export controls, they are in manufacturing bottlenecks and supply chain constraints, amongst other reasons. So problems with the waiver, I'll just go through them as I've heard them from member companies in no particular order. One concern I often hear is that the proposed waiver is too broad. It's basically indeterminate, and no company can predict which of its technologies will lose protection in which country and for how long. Right? The waiver purports to be limited for use in combating COVID, right? Treating COVID, preventing COVID, diagnosing COVID. But it applies to all health technologies that happen to be useful in achieving that goal. The majority of products, of IP protected products that would be affected by the waiver, would actually be general use products, right? Products that happen to be useful in combating COVID, but that are general use products. Name it, right? Medical glass, intensive care, supportive care, treatments and equipment, and the like, right? So things that are useful for all sorts of purposes, including COVID, would be captured. And it won't be possible as a practical matter to limit the implementation of the waiver, for example, waiving patent rights, only to certain purposes, right? You can't, it's going to be very hard to waive patent rights only for certain purposes, but not for other purposes. Equally, it's going to be very hard to deny the grant of new patents and condition it, if you will, only for certain purposes, but not for others. Right? So in other words, the expectation is that once IP rights are waived, they're going to be waived for all purposes, effectively and realistically, and not just for the purpose of dealing with COVID. And that has implications for platform technologies and general use technologies. Likewise, the temporary limits of the waiver right now, there are, as the waiver has been proposed in the most recent proposal, no temporary limits, right? What is being proposed is an open-ended waiver of IP rights until the WTO decides to terminate the waiver, which means that a handful of WTO member countries, once the waiver is passed and implemented, can block its termination forever. Right? There's no expectation that that the waiver would really have a date certain when it would end. And of course, like depending on the nature of the rights that are being waived, the waiver would be forever. This is especially true for trade secrets, which I think we may get into a little later, right? Being a professional lawyer audience, all of you will appreciate that the right to trade secrets depend on non-disclosure, right? Once a trade secret is made public, it is waived, it is gone forever. It can't be limited geographically. Once a trade secret gets out in Ghana, it gets out for the whole world, right? And it can't be limited by purpose. Once a trade secret gets out, it's in the public domain and can be used for any purpose, not just for fighting COVID. So trade secret information or biological materials and production cell lines, once they're shared, cannot be unshared. Information that's once disclosed cannot be undisclosed. So the waiver is not limited by time, and it's going to be very difficult, if not impossible, to limit by purpose. I'll mention a few other observations that I very often hear. One is that the waiver does lack support and evidence and experience, right? The experience in our industry has been that the response to the COVID crisis has been characterized by an unprecedented level of cooperation and unprecedented speed of developing products, right? There have been no credible instances where IP rights have blocked or held up the development and the ramping up of production of COVID countermeasures. And it's baffling to a lot of our member companies to see how the debate moved past this lack of evidence proof, if you will, where you would expect the burden to prove the need, for example, of a COVID waiver. You would expect the burden to be on its proponents, and somehow they've carried that burden in the absence of proof that IP has presented genuine obstacles to fighting the COVID crisis. I will end with, I will pick only one other thing with which I will end, and that is the notion that once we waive IP rights, it would unleash a wave of COVID manufacturing from like idle global capacity that is believed and said to exist around the world. Well, that I think is a difficult proposition that we also are not sure what the foundation for that is. But the belief that there is a lot of idle capacity that would be unleashed, I think is often overstated. We don't have a lot of good information of how vast this idle capacity is. It's likely that some exists. It may exist at the wrong point in the manufacturing chain. So for example, taking yet another fill and finish or bottling plant under contract is not going to help if there's no glass vials to fill vaccine into or no vaccine to fill, right? So I think when we talk about idle capacity, I think it's more necessary to have a more granular discussion of what capacity are you talking about and where in the production and distribution chain that capacity sits. Only a handful of countries are likely to benefit from the IP waiver, at least in the medium term, right? The main beneficiaries of the waiver are likely to be countries like China, India, maybe Russia, and a few other countries that have existing manufacturing capacity and that would be able over the course of perhaps 2 years to come up with manufacturing. The waiver is without more, and certainly not in the short term, is not going to benefit the poorest countries in sub-Saharan Africa and elsewhere that rightly complain about finding themselves at the end of the line, right? It is going to increase, however, their dependency on more Chinese or Indian imports of copied products. Final word on that. Of the 12 or so vaccines that are currently authorized for human use, criticism of the waiver proponents really focuses only on 4 vaccines that originated in Europe and the United States. The other 8 vaccines were apparently developed in China, India, and Russia without interference by IP rights whatsoever. Right? No criticism is leveled at these countries. There's no clamor for access to technology to these vaccines, even though there's no particular reason to be derisive of these 8 products that are being used, frankly, in a lot of countries around the world. That too, I think, is something I often hear from our member companies to say, well, how come that this whole debate, even though there's a dozen of vaccines around the world, focuses in and homes in on only 4 vaccines, frankly, only 2, because this debate is converging more and more only on mRNA-based vaccine technology. So is it that? Is there something about mRNA-based vaccine technology, the most advanced of the vaccine technologies that we are using now, that is attractive to proponent countries, right? Is it that what they want? Because apparently they don't want to make Sputnik or the Chinese vaccines, they want to make the mRNA vaccines. And in that respect, everybody needs to understand that mRNA vaccines are basically repurposed technology, right? This was not meant to be a COVID vaccine. This was meant to be a drug development platform for cancer products, metabolic diseases, and other purposes. This technology will have, in the long run, it's greatest utility in producing things that have nothing to do with COVID, right? And handing this technology over to anyone who asks will not help fight COVID, right? It will only serve to divert scarce inputs, resources, and raw materials away from up and running manufacturers to new and inexperienced ones. And at the end of the day, it will be used to manufacture products that have nothing to do with COVID under cover of the waiver, right? So this is a range of concerns. We hear very emphatically that the problems that need to be dealt with really do need to be dealt with, and they lie in the range of export controls. They have to do with capacity building. I think there will need to be capacity building in the global South, right? And not just in India and China, but also in countries, for example, in sub-Saharan Africa. This will have to happen, right? Whether it's the solution to the COVID crisis right now is a different question, because building capacity takes time, resources, and commitment, and voluntary technology transfer that will be very hard to compel, especially in the short run, through a COVID waiver.
Thank you. I'd like to bring Dean Baker into the conversation. So Dean, you've spoken about how the status quo is not working with regard to getting vaccines to low and middle income countries, getting vaccines into people's arms. What are your thoughts on the waiver proposals? Is this a false solution, or could it have a meaningful impact?
Well, I think it's very much a part of the solution. It's not the whole solution, clearly, but this would be a very, very important step. And the way I think about this is, you invite someone from the United States here, and we're going to talk about the United States, the U.S. perspective. I think it's World War II. I mean, we're looking at a situation, we know hundreds of millions of people have been infected. 4 million have died by the official tallies. We know the actual number is clearly much higher. How much higher, we don't know. Many others, of course, have been ill and will probably have lifelong, or at least long-term effects. This is a crisis. I mean, if you think that's a crisis, I mean, that's a lot of people, and it's going to be a lot more before it's resolved. And, again, I was mentioning World War II. Well, World War II, we did everything we could in the United States to try to win the war, defeat the Axis powers, Germany, Japan. And we overrode a lot of our rules. And, I think of this when we talk about the technology. I think if Boeing or Lockheed or someone had developed a new radar that was going to be very effective in helping us detect German bombers going after our troops, our sites, whatever it might be, and they just said, well, we have patent rights. We're not going to share that. I mean, that would be almost inconceivable. First off, the companies wouldn't have said that. But if they did say that, we would have overrode those rights. And this idea that, oh, we don't know how long this will last, we don't know, it could be applied to other areas. This isn't complicated. It's an emergency. You share the technology now, and after the fact, you worry about the compensation. No one's going to be entirely happy. We get that. But the point is, this is an emergency. Let's deal with the emergency. And again, if we think back to World War II, that's what almost everyone in public debate would have said. Deal with the emergency. We'll worry about the compensation later. And I understand drug companies want to make profit. That's what they're there for. But we could worry about that later. Now, in terms of the practicalities, sure, this all takes time. I don't know how many people I was arguing with 6 months ago. They say you couldn't just build a plant tomorrow. It takes months. Okay. Yeah, it would be great if we had this resolution. The waiver proposal was introduced last October, 9 months ago. Would have been great if we could have started taking action then. We didn't. Be great if we could start taking action today, because better or worse, the problem is not going away. And in terms of, the practicalities, again, everyone understands this takes time. So let's take actions, but also it's important to understand the idea that somehow the industry has all the knowledge here, they have all the expertise, nothing could be improved. That flies in the face of reality. So I'll just take what I know, which I'm sure is a tiny, tiny fraction of what's out there. February, Pfizer issued a press release saying they discovered a technique that would allow it to cut its production time of its vaccines in half. Okay, well, that's great. That's great. But maybe someone else could have discovered that sooner if this technology was open sourced, it was available to the whole world. They also discovered that their vaccine doesn't have to be super frozen. That doesn't have to be kept at minus 70 degrees centigrade at all times. It could be kept at normal freezer for up to 2 weeks. That's a big deal, particularly if you talk about the developing world, where maintaining those super cold temperatures is, of course, extremely difficult. Well, again, maybe that could have been found out sooner. And just to take, to my view, the most extreme case, it turned out that the vials that they were shipping their vaccines in contained enough serum for 6 vaccines, not 5. So initially they were throwing out 1/6 of their vaccines, 16% of their vaccines, at a time when the vaccines were incredibly short supply. So, you know, the idea that somehow all the knowledge, again, I'm going to pick on Pfizer because I'm sure if I knew more about the other companies, I could identify problems or limits in their production process as well. But the point is, if we open source this technology, we could almost certainly see more innovations that would allow us to produce more quickly. And again, obviously we need more facilities. We have to ramp up as soon as possible. And Hans makes the good point. Yeah, right now it's a relatively small number of countries. I'd also would have added Brazil and South Africa certainly to that list. There's some others as well, but it's a relatively small number of countries that have facilities that can manufacture them. But that's what we have now. So yes, it would be great if, you know, the manufacturing facilities were more widely dispersed throughout the developing world, but you have to start somewhere. So again, seeing this as a crisis, seeing this as an emergency, seems to me we have to do everything possible. And that means getting intellectual property out of the way as an obstacle. It's not the only obstacle, but it's certainly a very big one. So I'll stop with that.
Hans, I see you shaking your head. Do you have any follow-up that you would like to give?
Dean is of course right in that this is an emergency and it's a situation of extreme urgency. In fact, I think that is, you know, a recurrent and I think publicly persuasive argument that's often made in favor of the waiver. Right? But it's an emergency. Let's waive IP. Right? The connection between whether it's a real solution that will achieve and the proposition that's on the table is lacking, however, right? It is an emergency, yes, right? Do we need to waive export controls? Yes. Do we need to look into supply chain robustness and important inputs? Yes, right? IP, again, it's very difficult to see where IP has been a problem or where it is a problem. It's not that companies that are involved in making vaccines or their inputs aren't strenuously working to expand manufacturing capacity and supplies, right? There are, I think on record, we have counted almost 300 R&D and manufacturing collaborations that have been struck. So including in the global South, right? There are manufacturers and right, there's fill and finish activity going on in South Africa, for example, manufacturers in Thailand, Brazil, South Korea, India, and other countries are in fact contributing under collaborative licensing and tech transfer agreements to filling global supply, right? So it's not that I think the companies that have been involved have not been active in this space. So it is an emergency, and it has not been business as usual, I would say, for the industry and the private sector, which has never moved with as much as quickly as it has during the course of this crisis. I don't think that the World War II example, I think, is a really good analogy to what we must do today. It's true, but in times of national crisis, governments can use all sorts of coercive power to require corporations to act in the national interest. But again, a national interest, I think, is the key word here. If we developed a new radar that would detect airplanes coming in, I don't think those radars would be handed over and put in the public domain for the whole world to use, right? This is not how governments think when they invest. And that, I think, also goes to the often emphasized, correctly, public investment in the development of COVID countermeasures, in particular vaccines, right? The public has invested and contributed to the quick development of these products. Companies have too. To the extent it is a success, it has many fathers, right? But at the same time, I think the investing governments have gotten what they bargained for, right? The US government invested heavily in ramping up of vaccine production capacity, and in return, they secured, the US government secured for itself the supplies of vaccines sufficient to vaccinate the US population 2 or 3 times over. Right, that was the deal. And I think that was the deal that both the government and industry stuck to for a while. Right? Other governments have not invested as much. They've maybe been more busy bailing out airlines and other things. So, so the fact that there's been a lot of public investment, right, while undeniably true, isn't like directly related to the proposition that the technology needs to be put into the public domain for everyone to use. The greatest worry, however, is that the patent waiver proposal is going to end up, especially if it involves compulsory transfer of technology, is going to end up being counterproductive, right? It's not going to increase, quite possibly decrease global vaccine output. Again, by diverting, for example, supplies and manufacturing input away from up and running manufacturers to unlicensed new market entrants who are manufacturing vaccines for the first time and are very likely to do so with decreased efficiency, at least initially.
Dean, there's a couple, I apologize to jump in here. There's a couple of questions in the chat box relating to this current topic of discussion that are directed to Dean. So I'm just going to go ahead and bring those into the discussion. So one person asked, is requiring people to disclose technology without, respecting their protection going to make it difficult to deal with a future pandemic? Will this lead to delays in drug development if there's another pandemic in the future? And a second related question was, what does it mean to make the technology open source? Isn't the technology already public? So Dean, I was wondering if you had responses or thoughts on that.
Yeah, those are two very good questions, and they, fit in perfectly with what I was going to say in response to Hans. I actually loved his comment about, we wouldn't have wanted our radar technology to be open source, and that's for the simple reason this is a military technology. So, take the more extreme case, our latest bombs, we don't want to put them on the web for Al-Qaeda or whoever to get, yeah, that makes good sense. When we're talking about technologies in the healthcare area, the downside is someone else might pick that up and find new ways to treat cancer or, some other disease. That doesn't strike me as a bad thing. I get the companies that want to make a lot of profit on it are very unhappy with that, but that doesn't strike me as a bad thing from the standpoint of, the people of the United States, the people of the world. So I don't see the downside there. I recognize they have claims, they should be compensated. I get that. But, the point is, we'll deal with that now. We'll worry about the claims, worry about the compensation. Now, in terms of, what about future pandemics? Again, this is one, obviously people raise this all the time, reasonable question, but it has me scratching my head a little bit. Because if you look at the manufacturers here, we'll pick on the mRNA ones, but if you want, we could take AstraZeneca. It doesn't matter. I mean, I want to single out just Pfizer and Moderna. They've made enormous profits already. Now, obviously, they'll make more if they could maintain full intellectual property rights. There's no mandatory transfer of technology. Sure, they'll make more money. But I'm just thinking from the standpoint, if we had the CEO of Pfizer and he's sitting down and saying, okay, we're thinking of working on this new technology and we know there's sort of big risk, it won't pay off at all, but there's some probability we'll develop a successful vaccine treatment, whatever it might be. And then for year 5, 6, 10, whatever it might be, however number of years, we'll get a normal profit. We'll get, we'll get a return on investment. But there's some non-zero probability, is it 1 in 1,000, 1 in 5,000, that we'll get a pandemic bonanza. Okay, so that might be included in their thinking. So, but if they see us require technology transfer here and they don't get that pandemic bonanza, does that mean they won't undertake the investment? I think that's a little hard to imagine. And of course, the other part of the story is, everyone acknowledges there was massive government involvement. I mean, the one thing I think people have to give Donald Trump credit for, he had Operation Warp Speed that certainly helped speed up the development of the vaccines here. And again, that's a substitute. So insofar as we face a crisis like this in the future, I think there's a great lesson here that, particularly in the case of Moderna, the vaccines were developed basically entirely on the government tab. I mean, I know they had a platform that they needed to build on, but if you actually look at the development and the testing and the vaccines, that was almost entirely on the government tab. So I just find it a little far-fetched that somehow we're going to be in a situation where the drug companies are going to fold their arms and say, well, it's just not worth our profit. Look at what happened to Moderna and Pfizer. They only made, a few billion, not tens of billions. That seems a little far-fetched to me. So I just don't think there's that big a concern that this is going to impair our ability to deal with future pandemics.
Given the direction of some of the questions in the Q&A, I'd like to switch gears a little bit and talk about know-how and trade secrecy, just with the panel as a whole. So we've heard a lot about how these vaccine manufacturers, these pharmaceutical companies, have a lot of technical know-how. They have special information protected through trade secrecy with regard to how to produce these complicated vaccines, especially with regard to the mRNA vaccines. Is know-how and trade secrecy the bigger issue than just patent law? What about data exclusivity? Are all of these things, going to be the bigger concern with regard to getting vaccines, manufactured quickly? And whoever would like to respond first, go ahead.
I think that's clearly a very big problem. Which is the bigger one gets hard to say. And obviously they overlap hugely. So, I mean, one of the things that, I'm sure occurs to everyone, that when you say who has the know-how, okay, well, some of it is reverse engineering. That's not going to be easy, even for sophisticated manufacturers, particularly with the mRNA vaccines, because they don't have experience. With the adenovirus vaccines, perhaps easier. But, again, there's not, that will be a problem. But you do have people that used to work for these companies. Now, would they be willing to share their knowledge? Well, they might be if they get a lot of money for it. Now, are there then, all of them, I'm sure, are subject to non-disclosure agreements. They could then be sued by their former employer. That would be an issue. But, so that's where you get a difficult overlap question. So if you have someone who used to be an engineer at Pfizer or one of the other companies, and they're prepared to work with an Indian manufacturer or Brazilian, whoever it might be, that would mean violating a non-disclosure agreement. How is that enforced? Does that prevent them from moving forward? In other words, could they move forward and then worry about the compensation? I mean, that's what I'd like to see. But that's, so do you call that intellectual property? Do you call that know-how? That gets to be semantics in my view, but clearly that would be an issue.
I agree that I think Dean's right there. I think the more thorny and more difficult to think through issues relate to soft IP rights like know-how and also biological materials, right? Tangible materials that you might need for manufacturing, like production cell lines or constructs. I think these pose more interesting questions, I think, to my mind, than patents, because the patent landscape, depending on what you're looking at, say the COVID vaccines, at least globally, aren't very developed anyway. Half the countries that actually are supporting the TRIPS waiver are operating under an existing waiver from TRIPS obligations already, right? Least developed countries, all whatever it is, like 60 of them, don't even have obligations to follow. And with respect to manufacturing countries like India and China, there's not a lot of, I think, patents when we focus only on vaccines that they would have to contend with. But the same is true for Africa. as a general proposition. So trade secret rights, most questions that I get are more pragmatic, right? And they ask, how would that even work? How would you require the disclosure of unpublished information that's not captured in regulatory dossiers, right? But that's really in the possession of manufacturers. How would you compel the disclosure? How might you compel its disclosure across borders? Right? It's working in the United States. I'm kind of wondering, how might this be done? How would the US government, well, first of all, I guess, have to override the trade secret laws of 50 states, right? And then, require or somehow drive the disclosure of such information for the benefit of foreign governments, right? This is not meant to benefit the American public primarily, right? The declared goal is to enable and unleash, for example, countries in Africa to make their own vaccines. But how would that operate in US law? Would they send like armed guards in, walk into the factory and walk out with blueprints and biological materials and that's it? How would that be better, even if you found other mechanisms, right, to drive and compel disclosure? How would that be preferable to collaborative R&D and manufacturing license agreements of the kind that have been struck, right? So as between the two options, one seems the pragmatic goal would be to incentivize companies and enable them to both export vaccines that are made here and to transfer technology with suitable partners, including in the global South. But it's much more difficult to imagine from a practical perspective how you would do this on a non-consensual basis and constrain the disclosure for the purpose that the waiver purports to serve, right? Only COVID. Because as I said earlier, once you've moved trade secrets into the public domain, they're not purpose limited, and they're certainly not time limited.
Yeah, those are very good questions, and I think there's some simple answers to it. The way at least I would look, if they put me in charge of this, to compel disclosure is first you would try to do it voluntarily. You would again, we'll pick on the mRNA manufacturers, but it could be across the board that we want you to disclose all the information and open source it. I do want this to be open. I mean, that would be the idea, that you want the whole world to be able to look at the technology, to be able to build on it, be able to try to improve on it. Would you be able to get Pfizer? Would you be able to get Moderna? You put the money on the table. I don't know what would be fair. I'd have to think about it. Would that be $1 billion? Would that be a $2 billion? Whatever it is. I mean, there's some number out there that would be fair compensation. And again, to my view, you could worry about the exact number later, get the deal. If they just said no, if Moderna, Pfizer just fold their arms, go, we're not interested, we don't care. Well, you can go around that. You could offer their top engineers, how about $1 million a month? You're going to share the information. Of course, Pfizer would sue them, Moderna, and we'll say, we'll indemnify you. We'll cover whatever they sue you for. We will cover that. We want the information shared. That's how you do it. You don't have to force anyone. I suspect there's people at Pfizer or Moderna who, for $1 million, maybe $2 million a month, whatever it might be, I think they'd be willing to share the information so that the whole world could benefit. And in terms of U.S. public, we're very concerned about the Delta variant here. In fact, Pfizer's been telling us we need a booster. I don't quite buy that, but they're more expert than I am. Maybe they're right. Well, what if it turns out to be the case that there's a variant that develops that makes the vaccines most of us have received irrelevant? So we're suddenly back to ground zero. So we have to wait for them to develop a new vaccine and then mass produce it to inoculate, hundreds of millions of people in the United States. Just talking about the US. That's the American interest. Now, we have America first people who think that if it's not in the United States, it doesn't affect us. I get that. That's, I don't know, 20%, 25, maybe 30% of the US population. But I think most people in the US understand that it's in our interest to make sure that this pandemic is stemmed as quickly as possible. Again, I would like to think as a humanitarian matter, we think it's important that we not have millions of people die in sub-Saharan Africa, Latin America, South Asia, wherever it might be. But beyond that, we could just say, okay, let's ignore that for a moment. we have an interest in trying to stem the spread of this pandemic as quickly as possible. So it shouldn't be hard to tell people that, yeah, we want this technology shared so that we could get vaccines, and let's not leave out treatments and test, the other items. Those are important too. But, first and foremost, I think we rightly focus on vaccines as most important in stemming the spread.
We haven't heard from Tony in a bit, so I was hoping to loop Tony back into the conversation. Let me throw out a question that came through in the Q&A specifically for you. If you want to address that or another topic, feel free. So the question earlier from Darren Smith was, right now the way we're doing it is the WTO is looking at these waiver proposals, and then the individual member states would have to act in changing their national laws. Would it make sense to do it in the opposite order first, for countries to figure out what they need to do or want to do nationally, and then figure out what WTO needs to do to make that happen? Are we going about this in the correct order, basically?
Really good question, and it gets to some of the practical dynamics of the question, essentially of implementation. And I think I can scoop up this question as well as that really valuable discussion between Hans and Dean just now on trade secrets. And I'd focus initially on the question of, what in TRIPS is undisclosed information. And that term is used precisely because for two reasons. There's such a broad range of legal mechanisms at the domestic level that are used to protect undisclosed information or confidential information, know-how, trade secrets, etc. But also it includes quite distinctly the category of clinical trial data and the approaches taken to protect that against unfair commercial use. And I think it is fair to say that the debate about what it means, to make use of the options that a waiver would provide is still open. And there hasn't been a great deal of analysis about how to use the options open specifically. And that's something I might say that the practitioner perspective, the practitioner point of view, linking the broader policy debate with the domestic legal systems is particularly insightful right now. For example, one area that, and one reason why this area is difficult is because there's just less understanding about it in the international policy space. Patent law exceptions, compulsory licenses, government use orders, and so on are at least much better understood and known about and are more comparable in distinct national laws. Whereas in the area of trade secrets / know-how / clinical trial data, they are much more heterogeneous in domestic legal systems. And therefore, there's less of a broad understanding of what it means. In particular, what we're talking about is what it means to override the protection. One useful thing that I think has come out recently in the debate is a clear understanding that, for example, for clinical trial data, there is the option already under TRIPS of overriding protection in the public interest. It's not absolute protection. Reading TRIPS, it's just less clear. It's one very succinct paragraph. Basically, it says protect clinical trial data against unfair commercial use. That's it, and that's the standard. And exactly what it means to apply that standard has become a very important debate. I don't think anyone's maintaining that any form of IP in any situation is absolute. We just don't know. We have less of a sense of what it means, even within existing laws, to override that in the public interest. And I think that's why the focus on undisclosed information in both categories is important. Why have governments not, if you like, put forward a specific list of the precise areas that they wish to see waived? I can't speak on behalf of the proponents, but I think one theme that's come through in the debate is this is to establish. It's like a precautionary approach to have available the freedom of movement. I mean, the debate over the waiver has already continued since October. And if it was a matter of individual countries having to come to the General Counsel, as it were, one by one, article by article, I suppose the proponents would say that is simply just unworkable. If a decision has to be taken quickly to remove a particular IP barrier, it may be in an emergency situation, it may be an executive order, then it would be difficult to take this through the whole procedure in the TRIPS Council and the General Council. So the idea is to have a kind of a blanket coverage to allow for any eventuality. And I want to stress I'm not advocating this, I'm not taking sides, if you like, but I think that would be the way that the proponents would answer that question.
So one question that's come through the Q&A box is with regard to compulsory licensing, which Tony touched on. Should the ultimate goal be that, parties push for a full IP waiver, but then we end up at a compromise position, which is to make compulsory licensing easier? Would that be a good middle ground, that we allow, not just allow 31 TRIPS Article 31 to be used, but without hindrance, without the usual US goes and retaliates, or the kind of same old behavior that we've seen in the past? Would that be a good compromise? And Hans and Dean, would you like to comment on that?
I can go first if you. I mean, I'd say anything that makes vaccines, and ideally, again, treatments, tests, the other items that we need to deal with the pandemic more widely available is a step forward. But again, it's not what I would want to see, just because it will help the situation, and yeah, that's good. But I still think it's much less than we could do, and in the sort of situation we're facing, I think we really need to be, removing every barrier that's there to try and get these vaccines, treatments, tests available absolutely as widely as possible. So if that's what at the end of the day we get, well, that's progress. But I think that's way inadequate for the problem we're facing.
Yeah, again, I think it's worth towards the end to reiterate, the end goal, I think, is shared by all. But absolutely true. What we need to do, what's most effective, most reasonable, and most efficient at getting more vaccines available around the world, both in the North and in the South, to do this. It is, I think, striking in a way that as you follow the debate and how it has evolved over intellectual property rights and the COVID crisis in particular, if you follow the debate from the beginnings of the COVID crisis, in the beginning, the first months of last year, February, March, April, and so on, debate from, for example, the NGO community was all about compulsory licensing and patents, right? And over the course of the year, as vaccines became developed and were nearing deployment, and as we began to see which ones would work and which ones didn't, only then did the debate change away from patents and the use of TRIPS flexibilities to a new, much broader proposition. Right? The same activists and groups who for decades have argued with significant success and traction, right, for ever expanding TRIPS flexibilities, right, are now saying that it's not even worth trying to invoke them, right? Forget all that. We're not even going to try doing this. We want this other thing, right, which doesn't require compensation, which doesn't require a justification, if you will, or legal process for rights holders. We're going to do this other thing because it's a crisis, right? But crises of this kind have been invoked in the past as well in support of compulsory licensing, right? Very much of the debate actually has centered around HIV, right, which is used as a major justification for taking the TRIPS waiver now. And yet the proposition is a completely different one. It is operate outside of TRIPS instead of within its constraints.
I apologize. I'm going to have to jump in because we are at the very end of our time. But I want to thank all the panelists for really exploring the different issues in this debate. I wish we had so much more than just 1 hour, because there's so much more to talk about that we didn't get into today. And let me turn things back over to Sharon Israel for a brief wrap up, and then we can conclude.
Thank you, Sapna, and thank you to all our panelists for a great discussion. Obviously, we could continue on for quite some time, but I think that our panel gave you some good insight into the complicated issues that are involved in this important topic. Thank you on behalf of AIPPI, on behalf of the standing committees on free trade agreements and on TRIPS. We really appreciate everybody's involvement in today's participation and involvement in today's discussion. And before we close, I just want to remind everyone that you can sign up for the 2021 AIPPI World Congress that will be held October 15th to 22nd. It will be virtual. It's online. The early bird deadline is August 24th, and then for AIP, both for AIPPI members, and you can, if you're not an AIPPI member, I encourage you to join. And you can see the registration information on this slide. I also put in the chat a link to the AIPPI's position paper that's related to this topic that you may find of interest as well. And with that, I wish everyone a good day or good evening. And again, thank you so much to our panelists for sharing your perspectives on this very important issue and for providing us such an engaging discussion. Our presentation will be available on AIPPI's YouTube channel if you missed it, or if you'd like to missed any of it, or you'd like to have it shared with any of your colleagues. Thank you again.
Thank you very much.